Okay, then thank you very much for your presence and good afternoon from Macau. I would like to share some of my more recent works because due to the frustration with the global pandemic, I was somehow, and especially with the paralysis of the field that I usually teach, world trade law, I looked into fake news more, and especially between the pandemic and fake news, there has been a connection that was made now, and this is in particular like the kind of observation that fake news are spreading faster than the virus, and with it some conspiracy theories. And at the same time, when I was looking at that, I was asked to write a short book review about a book about legal fictions, which then also made me realize that actually the law loves fictions much more than I ever thought. So I thought this is an interesting like field to look into, and I'm happy to share today some of these results. First, a problem with fake news is generally, in my view, how to define information. What is information? And the statement that I like the most is actually pretty much the etymological meaning, which is not just information as data, but really something that gives form to something and that shapes something. So in fact, it's a very broad definition, but I think this is a bit like the butterfly effect in weather. Any sort of information will have a kind of impact on us. On each of us, and that of course is something very tricky when we consider that in terms of legislating maybe what is fake and what is real news. But I think we have to start from a very broad definition, and then we also see, of course, that here the senses come into play. I will not talk too much about that, but this is also a field that interests me a lot, like especially the fragmentation of the senses and how new technologies with virtual reality and so on, augmented reality, how these developments may have an impact on the law and may require us lawyers also to change how we approach the senses individually and whether we join them. But we see, of course, from the dress, you remember that maybe that people were divided over the same information, like an image of a dress being seen white gold by some and blue and black by others. And I do it every year in the classroom, and it is always the same, that it's a division almost of 50-50 or 40% and 20% can see both sides of it, which is also very interesting. And then, of course, another interest is paradoxes, oxymoron, and everything. And this has been mentioned in several publications, that we live in a time of paradoxes, that we have much more information, but we know less and less, basically, to put it in a short way. This I have also here. This is an interesting story. You probably know that. A dilemma we have, that if you read the newspaper, you're uninformed. If you don't read, you're misinformed. No, the other way around, actually. But both these statements were attributed to different authors and are themselves called an example of fake news now. So this is very interesting, how fictitious statements are like becoming attributed to someone, and then the whole thing derived from a fiction in a way. And here I also, of course, looked at language in a broad sense. What is the information that language brings to us and how that alters our perception, our actions, and ultimately the law? That is also subject of, actually started with the interest in my book, in which I was also surprised, because when I reread the foreword, which I had written in 2017, even a year before it was published, I already said, at the time, I kind of predicted that the situation of the law in the future is like a new pandemic global disease, which unfortunately, like just 2 years later, materialized. And in many ways, this pandemic also, this kind of coronavirus disease, is also a kind of mirror of, I think, and brings many problems to the fore that we have neglected in law for too long. And the argument in the book is basically, as most of you know, actually, that this terminology is increasing of concepts that are contradictory and contain or reflect paradoxes and oxymoron. And in fact, there are plenty of sources which have identified fake news as an oxymoron like this one, and also related concepts that very much appear in this context of fake news, like alternative facts, social media, virtual reality. They have all been defined by experts in their fields as falling into this category of an oxymoronic concept. So that is what prompted me also to look at these fake news as an oxymoron, and what we can learn for the regulation maybe of such news that disinform and misinform us potentially. And here we have a paradox in itself that David Held in his book Cosmopolitanism, I think, phrased very well. The paradox of our times is simple. We have a lot of global problems, but only locally and nationally address them, and we can't even think in global terms. And it is very obvious when you look at, I've experienced this now in Macau for 16 months, where I have basically, there is no way to travel abroad or return without quarantines and so on and other restrictions. And you see also that almost like day and night, countries open up and then they go into lockdown, but never in a coordinated way, which means that while it is safe in one place, it spreads in another, then they react and so on. It's more like a table tennis game than a coordinated action, and let alone a global strategy. And the same is with fake news. Fake news, there are plenty. There's a website which traces various national efforts to legislate against the spread of fake news, but there is no global concerted strategy. And of course, in this age of cyberspace and the internet and so on, the problem cannot be contained locally like a virus. In fact, and social media are also not contained to, despite several efforts to that end, but they're of course, in a way, it's a World Wide Web. There have been some attempts at the international level, quite interesting, in the 30s and in the 50s, but these are basically dead letter international law, because they are either not ratified by more than 5 countries or something, and anyways, there is no mechanism to trace and correct maybe false information. And I wonder also who would be able to keep up with the quantity of fake and misinformation that is spreading on social media to comply with such a convention, regardless of another flaw that this is applicable to member states and not to individuals and private corporations maybe, which are behind, and even robots and artificial intelligence, which may be behind the spread of misinformation through these bots and so on. So the question is then, what is fake, what is true, and who determines that? And that also determines, in a way, how the future will be. Will it be law, will it be science, or will it be fiction? And in one article that I published a year ago about the future of the world, I tried to make a scenario which all right, can you see it? Yes?
Yes.
Okay, so in this scenario of law, science, or fiction, I think I gave away already that I think that they all play a role in the design and the way the future unfolds. And in fact, in the book Homo Deus, not by any chance, also a kind of oxymoron, he also writes that fiction has become more important than even asteroids and natural selection, and we must understand what kind of role fictions play, I think, around us, and not only legal fictions. And here I want to give some examples of information I've been tracking a lot, information that I received about the coronavirus, and that any citizen is exposed to, actually, and any consumer of news. So to start with, in a way, you see on the one side the BBC like saying there's a pneumonia outbreak in Wuhan, mysterious flu, and then by 11th of March 2020, the World Health Organization, in a way, determined that this is a global pandemic. So these are facts and news reports which started the whole thing. And then when you followed on social media, I don't know if you saw, there was immediately a post that a novel written in the 1980s predicted the outbreak of the coronavirus. Because in this book, it's a kind of thriller. There's a Wuhan 400 virus which escaped from a lab, and it was like made to kind of create the havoc that we are seeing. Interestingly, when you look then deeper at the book, I got an e-copy from the 1990s. it was actually said that in the 80s, interestingly, the virus was placed not in Wuhan, but in a Russian city because it was the Cold War. And in the second edition, they changed it. The Cold War was over in the 90s, and then they changed to China because there was a new, probably, challenge coming after the Soviet Union. So quite interesting. Who prompted that change? The author himself is very dubious. On top of it, it's very mysterious because the author has published before under different pseudonyms. So I don't know who that is, and I never knew about him actually before that. And here you see that excerpt from the ebook that I copied. And then also the media have picked up on these kind of work of fiction and said, no, he did not predict it. And they explained first wrongly about the origin in China because they didn't mention that it was actually in Russia. And then also like legal fictions. At the time I read a book about the legal fictions, and like Lon Fuller in particular said that no lawyer would deny that judges and writers on legal topics frequently make statements which they know to be false, and they are called legal fictions, and that it has real effects, like in a way that what's his name, Harari says, like, fictions like corporations, states, they're all fictions, and they own more land on the planet than actual persons, and they have more power than actual persons, and so on. So the fictions have real consequences, and that also is something we need to discuss and consider. And then there's an interesting example for legal disclaimers. When you write a fiction book, you usually say, well, this is all fiction, right? And it's purely coincidental that this doesn't exist. And of course, if you write a fictitious story, everybody knows you will draw from real facts. It's very difficult to make up a phenomenon that doesn't exist. So there is this interesting example of John Le Carré's novel, The Constant Gardener, which was made into a movie. I don't know if you've seen it, but it's a very good book and a very good movie as well. And when you look at the epilogue at the end, there is an afterword by the author himself, and he says, in these dog days when lawyers rule the universe, I have to make this disclaimer because otherwise I get sued, basically. And then he says, nothing in this story, nothing is really based on anything actual. So it's all fictitious. But then, and you go on, if you know the story, this kind of medicine doesn't exist, and so on and so forth. But at the very end, he says, but I can tell you this, as my journey through the pharmaceutical jungle progressed, I came to realize that by comparison with the reality, my story was as tame as a holiday postcard. So he reverses everything again and says, actually, this fiction is far like milder than the reality is in this regard. So I think this is an interesting example of fiction, not even exceeding the reality probably, but for legal reasons, he has to put it. And then we see another interesting example, more or less in a journal, Ochsner Journal it's called, and there's a medical, the vice president of this Ochsner Medical Foundation, and he wrote a short piece on the book by John Le Carré. So I think not long after the book came out. And he says, it is very interesting that a world-renowned master spy novelist who wrote about the Cold War and agents all the time turns to his eye on the pharmaceutical companies. And then he says also that we should take this story as a warning for the conflicts of interest that exist in this industry, the kind of there are probably scientific battles going on behind, and also the lack of trust in these companies, because we know that many of them have acted more for profit than for the sake of providing health and well-being. So he takes a work of fiction serious to consider the role of the pharmaceutical and the medical field in particular. That I find very interesting and quite a good example of how fiction can help us to understand facts and reality. And then you can, of course, turn to, when it comes to also kind of predictive programming here, to science. And here's a journal from a scientific journal published in 2007 from Hong Kong, actually. And they had studied the SARS virus in 2003. And then they suggested that SARS can return if the conditions are favorable, and then there can be a mutation, amplification, transmission of dangerous viruses. And then, I'm sorry, they also said that these viruses in horseshoe bats, together with the culture of eating mammals in southern China, is a time bomb, and it will, therefore, we need to be prepared, and that should not be ignored. Then you can again jump back to fiction, 2011. I don't know if you've seen another Hollywood movie. A woman coming from Hong Kong from a business trip becomes sick, and then there's a spread of a deadly virus, and they die, and so on, until a vaccine is developed. So pure fiction, 2011. And then 2015, for example, Bill Gates gave a TED talk in which he said there will be another outbreak, and we are not ready. And he warns of a virus, a pandemic, etc. And interestingly, he said, this is not Hollywood. And he shows this picture in this TED talk. I've also given a TED talk. I thought it is a privilege of, like, you know, in a way, scientific theories to spread new ideas worth like spreading. But he showed the picture here of this movie and said, we are not, unlike Hollywood, we are not ready and prepared, and how to deal with that. And then also, interestingly, there was this movie by Dan, based on the book of Dan Brown, 2016, in which, I don't know if you're familiar with it, a billionaire tries to depopulate the world because he thinks solving the problems of the world is mainly through depopulation. And then the interesting thing is the date of the release, which is actually the birthday of Bill Gates. So that is also a coincidence that some people use as a conspiracy to explain that there might be a connection in a way. Let's put it that way. Interesting is also in 2017, I have a copy of that book at home, and the asterisk, there's also the story about a racer called Coronavirus, and he wears a mask to not be to be anonymous, and he runs around Italy like in a race, and he's called Coronavirus, which is 2 years or 3 years before the spread. And interesting here also the date again, 19th of October, you will see, is a date that is important, because on around the same time, 18th of October, 19th of October, there was a 2-day simulation called Event 201, which simulated an outbreak of such a coronavirus, which jumps from bats to people or via pigs to people, and then it spreads from Brazil to other parts, and until at one point 2 years or something later, a vaccine is developed. Interesting, you can visit that event homepage. It was organized by the Johns Hopkins Center and the Bill and Melinda Gates Foundation, coincidentally, with the World Economic Forum. And they said that, to be clear, this is not a prediction, and we did not predict what happens, or in any way, we modeled a fictional coronavirus pandemic, which of course, when you take all these, hopefully these pieces I've produced now together, looks more than a kind of coincidence in many ways, like the dates and the persons who are involved in financially and also publicly and in Hollywood, etc. So it is interesting to see there's a rich interaction and kind of also alteration in a way in the developments between, I think, facts and fictions. And then there was also an article published in an Indian and by an Indian research team, which said there was an uncanny similarity of kind of proteins in that new novel coronavirus with HIV, I think, research. So they came to the conclusion that it was very unlikely that it was something not made in a laboratory. But as you can see from the original here, I mean the electronic original, it was withdrawn shortly thereafter for reasons I don't know exactly, but in a way it was deemed not maybe having, you know, we probably all have experience with peer review when things are reviewed blindly and what flaws may be found there. Ultimately, that leads us now with most recently, this is an article from the Le Monde, which stated in, I think it was in February, that basically now the virus, it is pretty certain by Le Monde, already since November in France. So the Wuhan explanation is maybe outdated in that respect. And last week, again, there were or 2 weeks ago, there started this discussion with Anthony Fauci, and he was challenged by a member of Senate that they were actually funding functional gain research, which is when you create a kind of Frankenstein virus, which is worse than the real one detected, in order to be able to prepare for the future of the mutations of the existing virus. But of course, and the interesting thing is, like, from a regulatory perspective, I also found that the US had a moratorium on such experiments between 2014 and 18, which was then lifted. And at the time they had the moratorium because they said it is very likely that maybe from such research it may escape from a laboratory, because many laboratories do not have the same safety standards and so on and so forth. So they had put a moratorium, tried to regulate it in place, but then they lifted it in 2018, and now we have a debate whether the US has actually, seems to be proven that there was cooperation between the American and the Chinese laboratory on virology, but of course it does not explain, and we don't know yet where the virus really originated from. But the important conclusion that I want to draw here is, and that is very much in line with also like studies, media studies and so on. Luhmann has written something that facts and fictions both influence our mind. They stay there as information, and the interesting thing is, in my view, whether something is now like factual or fictitious, it will influence us, and it will, the influence it has on us, the information that shapes us, will affect the way we act. And ultimately, whatever we decide to do is becoming a fact. So we have to be extremely cautious in that respect. And I think it is very important to be aware of the impact of fictitious information. At the same time, of course, and that's an interesting debate I want to have in the future, is we should also use that, because lawyers, when we pass a new law, we also create a fiction to perhaps change behavior, not to use the mobile phone while driving, right? Which first is a fictitious idea of a society of drivers not using the mobile phone while steering a car, until maybe it is through enforcement and other incentives, it is achieved. Which I think very much justifies our interest in law and literature and also related studies for improving actually and finding better ways to really control the future in the way we desire the future to turn out. And I think in this respect, we already have a lot of tools at our hand, but we need to sit together and discuss them and use them wisely. And definitely for the regulation of fake news, for example, I would say that it is impossible to kind of enforce, even formulate a law that would clearly draw the line between what is fact and fiction. And that is, especially in the times of oxymoron, we need to be very careful with this kind of like right and wrong thinking, exclusive logic, because things are much more related, and we have to adapt our senses and our logic and our whole perception to these new realities, which in parallel we create with new technologies, which affect our mind more and more, and neuroscience and law, and I mean, it is only a matter of time, and I think that computers will be connected to our minds, and will therefore, when you look at the new proposed EU regulation for AI, there are plenty of practices mentioned which will exactly predict that this will happen, and we need to step up clearly our understanding of our own mind and what we can do with this important tool. So this is, I think I'm up, the time is up to, and I look forward to maybe questions or feedback very much. And thank you very much for your attention.
Thank you very much for what is obviously a very, very fascinating topic and highly topical in our times. We'll take the questions after the next presentation. So let's call on Professor Amatian to present, and then we'll take the questions. Thank you again.
So, can you see that? Good. So, Thank you very much. Thank you very much for coming at this sort of quite early hours. People in China have an advantage. Um, and thank you as well for staying with me after all these sort of changes and postponements and so on. And what happened then, of course, was that this original abstract of my talk would change a little bit, or would sort of develop over the time. And so the abstract is not totally accurate anymore. I mean, I think I mentioned something about Salvemini and so on in the abstract, which is fascinating. But if I did put that in, the whole thing would come to a book. I think he deserves a separate talk or article in itself. So what I do is more looking at the sort of earlier parts of my abstract, and this is, I think, sufficient certainly for the talk and also for an article. It becomes quite voluminous, and I look at actually the idea of justice as a perception of justice and morality, and the relationship between law and morality. And legal theory is quite sort of engaged with that, but in a very peculiar way. Let's start with English law. There is the case which has also been mentioned or cited in the Pinochet case, which became quite famous in 2000. And that case, which was cited from 1924, said that a long line of cases shows that it is not merely of some importance, but is of fundamental importance that justice should not only be done, but should manifestly and undoubtedly be seen to be done. So it looks like as if there is justice happening, not only that it is happening. And if you're mean, you can say, well, as long as it looks like as if it is happening, particularly that there is no influence on the judges, no impartiality and all these kind of things, then you would probably assume that this has been just in content and in substance because it has been done in a just procedure. Now, lawyers, practical lawyers, people like doing commercial law like me, don't care very much really whether the substantive legal rules are also just. It's only important what they are and what the relationship between them is and what the case law says and whether there are contradictions and so on. So it's rather legal philosophers who talk about that. And they do actually equate ethics with morality, really. But then it becomes quite difficult because it would then more or less sort of be a sort of a quiet equation. Something is ethical, therefore it is moral, therefore it is good, and in legal terms it is just. And the problem is, of course, that we have got immediately the old is and ought problem, which was particularly discussed with the philosopher G.E. Moore sort of towards the beginning of the 20th century, where he simply said good, this quality of good cannot actually be defined because technically, analytically, good doesn't have parts which are composites of a whole. So you have got a horse, and the horse has got ears, and he actually gives the example of the horse, and it has 4 hoofed legs and so on. So you can, with all these kind of categories, define what a horse is. With good, you don't have that. So object of pleasure of desire is, it doesn't mean that this is good. That's a naturalistic fallacy. It actually means that you make a conclusion from a natural object to something which ought to be. And this is what philosophers, legal philosophers as well, and moral philosophers in particular do all the time. It is, therefore it is good. There is God, therefore it is good thing. Therefore it ought to be like that. And of course, the famous, probably first famous criticism of that was by David Hume in his treatise of human nature, which is one of these sort of excellent side remarks which became famous ever since in the book 3, part 1, section 1 at the end, where he simply said, I'm surprised to find that instead of the usual copulations of propositions is and is not, I meet with no proposition that it is not connected with an ought or an ought not. This change is imperceptible, but it is, however, of the last consequence. So if you say, You have got a moral quality of good in law, which is justice, although also people like Hart and so on, they don't, also Kelsen, who is otherwise very, very precise, they sort of assume that somehow. So justice is morally good, or is an attribute of moral goodness of some kind. And how does that then look like with this kind of natural fallacy or is-ought problem? Some philosophers say this is not exactly the same, G. Moore's natural fallacy and David Hume's is-ought problem, but I think for our purposes it is in our particular context. So if we test that, when we have the right to property is good, or the property is good, is a classical is-ought fallacy, because property is, or at least things are, and can then say, well, property is actually a normative creation. I would say that, but let's assume it isn't. But you have got things, physical ones, like this glass. And so it is good that I actually have ownership, so exclusive power over this. Which, of course, in political philosophy happens all the time. You know, this is particularly, you know, it's an essential part of the person's freedom is the ability to own property. So you can say that's Hobbes, it's particularly Locke, and was enormously important in the making of the American Constitution. No taxation without representation, which means taxation is an impingement of the ruler on property of the subjects. I mean, you can also turn it the other way around. You can say it is good to expropriate the rich, at least in parts, because everybody has a right to have property. So the poor must also have property because that's morally good. So you can actually twist that in whichever way you want. But everybody, at least in sort of ordinary meaning, knows exactly what good is, and that is interestingly pretty absolute in their perception. Now, this kind of absolute idea of moral principles was something Kelsen didn't like, and he, first of all, he very clearly brought out the is-ought fallacy. Is and ought cannot be, you cannot actually make a conclusion from one to the other. The normative and the factual are separated, and conversely, he says that very clearly in his pure theory of law, and there's no breach between these. And he also says, although he doesn't actually connect that directly, there is a strict separation from the ought, the norms of law, and the ought, the norms of morality, because what they share is that they are ought, they are not is, they are not facts, they are norms. However, the morals are social norms which are primarily addressed at oneself. That's what he says, and this is a quite common approach. I don't think this is absolutely right, but it's a different kind of thing. And so law is a coercive social norms which are addressed at all. So morals are not coercive. That is what is said. Law is, and it is addressed this whole society. And the ultimate foundation, the ultimate justification, foundation in Kelsen's system of pure theory of law is the Grundnorm, which is, of course, also a fictitious construct. So the form makes the law, the form, how the law appears and how it is actually created, and the wonderful German term is Rechtserzeugungsnormen, that actually makes the law, not the content, and therefore law has whichever moral content, but we don't care in legal science. This is not relevant to legal science. And Kelsen says very clearly, the task of the science of law is not to approve or disapprove its subject, but to know and describe it. Well, the interesting thing is, though, if you actually describe it in this way, you don't describe it really at all. Because you can't get away from the fact that there are morals in the law and effectively embodied in them. So there is some merit, of course, in Kelsen's scientific avoidance of the morals in the law, but because you can then study the system of the law and also the constitutional system, and it was quite instrumental in making the modern constitutional system and constitutional court, and what law technically is. But of course, we should never forget this is an X-ray of a body. A reductionist method for some forms of diagnosis. If you make an X-ray of you, then of course it's you, but it's not really you as a person. It's just an aspect of it, which is good for diagnosis. Oh, you have broken your arm. There's nothing wrong with that, but we shouldn't actually ever forget this limitation. Law embodies and enforces all sorts of moral values, even conflicting ones within one legal system. So the strict formalism of a pure legal science, which ignores morals, doesn't actually describe it really, to know and describe it. We don't know much about law. Certain aspects we know better, but not other aspects which are absolutely vital as legal scientists to know of. So the inquiry, critical inquiry of the morals is shut out for a lawyer on this basis, because you may actually see morals in the law which you don't like and you want to criticize them. You criticize the law, but indirectly you criticize the morals. And if you talk to an ordinary person and say, what's your problem? That's obvious anyway, isn't it? This is also what politicians do. Indeed. Why don't we admit to it as the scientists? Because that is absolutely vital. Also important where, for example, we have absolute moral systems, for example, religious moral systems. They're not the only ones, but they're the most typical ones. If we look into the Iraqi constitution of 2005 in Article 2, it says there, no law may be enacted that contradicts settled rulings of Islam or that contradicts principles of democracy. And you could ask, is that not a contradiction in itself already? Principles of democracy and settled rulings of Islam? Well, at least if you say that, you need to look at the moral aspect, because the law says very clearly that the moral system of Islam has to be introduced and has to be considered and has to be followed. Although the practical side, as I can see from the literature on this, is that Iraqi judges and lawyers are actually trained in a very secular way and wouldn't actually have a particular interest, nor see themselves fit to make any pronouncement as to what the settled rulings of Islam is. And the Shia, in this case, particularly the Shia religious leaders, tend to be relatively offhandish in Iraq as well to say very much about that. So this is sort of the legal or constitutional reality. But we need to say something about this if we want to say something scientific. Well, with Hart, we have got already a sort of pragmatic positivism, where he does admit to a minimum content of morals in the law, which I don't think you will have a particular problem with, but at least he admits it, that it is there. And the issues are human vulnerability, which has to be addressed, in approximate equality of human beings, which also means that we can actually really enforce a mutual forbearance system as well, which law also includes a base for legal and moral obligations to have a social life at all. The reality of limited and intermittent altruism of humans, hence we need to have coercive force in order to, well, we have to have coercive rules in order to bring in line those who actually have not the altruism, at least not at the moment. And the reality of limited resources, which actually justifies property, but not, and he says that quite clearly, individual property automatically. And then we need to have a limited understanding and limited strength of will, which necessitates sanctions for enforcement. We then have a more open acceptance of the morality in the law with Fuller, and quite clearly is sort of seen as a kind of natural lawyer. They do, Hart and Fuller had their sort of conflict, where I find it difficult to see where the problem is, really, because they basically agree on what Fuller says, and Hart calls them principles of legality in his concept of law in page 207, and you think, why do we actually have this fight between each other? There's not much difference between you, but here we are. Fuller says, the functioning of the legal system will fail if there are no rules as a basis for decisions. So you make the decision up as you go along. A failure to publicize the rules that are to be observed, an abuse of retroactive legislation, especially the idea of retroactive criminal laws, we come to that later, a failure to make rules understandable, the enactment of contradictory rules, also contradictory judgments, and then various other aspects, which means that this really is the inner morality of law. If that is not there, the legal system won't work, it will fail. You see these categories rather as procedural ones. They're not actually saying much about the contents of the morals as such. Now, if you look at the moral system, a legal and moral system in reality, as I've said already, law is imbued with morality, often conflicting moral norms. I mean, the idea why you have got marriage, why you have got the monogamous marriage in Europe is basically the legacy of ultimately Christian moral norms. I mean, if you look into African countries, things are different. Also in relation to your relationship to your mother, where you can have probably more who are basically socially your mothers. One of them is also the biological mother, but the others are actually also mothers, you know, this kind of thing. So we have got moral norms left, right, and center, not only in the family law, which are just having a legal garb. The next thing is, and this is a very important aspect, only because something is moral doesn't mean it is good. There's also an is-ought fallacy. Moral can be pretty rotten. It's a particular moral stance or standpoint which you don't approve of. And I give you an example, which is a quite inimical and vicious one, which is by Carl Schmitt in 1935, who is probably best known, or at least should be best known, as probably most foremost National Socialist academic lawyer, at least until the late 1930s. Then he fell out of fashion somewhat. And he wrote in 1935 a criticism of the Rechtsstaat, the positivist legal state, or a constitutional state, or you can also say rule of law. There is no really adequate translation in the English language for Rechtsstaat. And he said that the early liberal constitutional state had some sort of worldview and was capable of political struggle. The only worldview to which a positive legal state specifically belongs is a helpless relativism, agnosticism, or nihilism, which is sort of going against, really, people like Kelsen, who was also once his colleague. And so there is only a normative power of the factual. And so it's just terrified of the idea of the sentence of nullum crimen sine pena as an immediate justice. Notice, not nullum crimen sine lege, he says nullum crimen sine pena, which is also quite interesting. He's not interested in the sort of statutory basis of the crime and the punishment. He's interested in that every crime will be punished. This is slightly different. What we have got here is that Carl Schmitt at least is honest. He wants to clear out the liberal democratic values and wants to have the totalitarian fascist ones, but they are values, they're moral values, only rotten ones. And it is wrong, I think, that one leaves that discussion out as a legal theorist altogether, because then you have nothing to say about the morals, although they actually inform the law. And the next thing is, of course, moral values are not immutable or permanent, even if they pretend to be. And we have got that also, of course, in the religions. So, for example, the celibacy of priests before, after the Gregorian reform, because before 1000, Catholic priests were, of course, married. Or the writings of Aristotle, which were actually prohibited at one point, and after 1250s basically become part of the canon of theological teachings of the church and so on. But of course, they have to appear immutable in order to be convincing. We've got that in totalitarian systems all the time. We have got that, of course, in logic. Those moral values are ultimately determined by those who are in power. If you look into Lewis Carroll's Through the Looking Glass, the famous quote with Humpty Dumpty, question is, said Alice, whether you can make words mean so many different things. The question is, said Humpty Dumpty, which is to be the master? That's all. So legal theorists, and this is simply also, if you look at the people who do that kind of thing, usually American, white, quite privileged, friendly, professors in elite universities who think, you know, they operate benevolently for the sake of all people, for the common good, and they may think that really. The problem is, though, it's not the reality, neither with, for example, politicians, nor with the ordinary people. We've also got constitutional ruptures of this idea. So there's always sort of the background that we sort of liberal democracy with freedoms and equality before the law and all these kind of things. If you ask minorities, they probably tell you a different story, but that is sort of the ideal, which is fine. I don't have a problem with the ideal, but of course you can't shut your eyes and do some kind of abstract legal science without actually addressing these points. We have got constitutional ruptures. For example, the Supreme Court, which the example in the UK Parliament, which actually has sovereignty and is not bound by constitution at all. So it can actually be an autocratic institution. It is said that in theory, Parliament can abolish itself altogether. This is still held as the principle in British constitutional law, which causes problems. Also, what is the relationship between the UK and the EU if Parliament is not bound by anything, which is now a past issue, but also the relationship between Scotland and England, what this kind of constitutional devolution is really like. Then many people in democracies do not necessarily share democratic values at all, because they don't change much for them. Because if you're in a workplace, that's not democratic. Well, your family life is democratic, depends, but it's not necessarily so either. And then there's not much left in your life where you actually can exercise democratic values. Why would you then appreciate them? That is the basis of right-wing populism, which is very popular. Why are these people elected? Trump and others, you know. So the basis of morality is to be looked at, but should not be ignored, but is not as nice as legal theorists see. I'll give you then, this is sort of towards the end, a few practical examples. One of them is in the Sale of Goods Act. This is what I teach. And we have got the situation that we have a question of liability for lack of satisfactory quality and fitness under the Sale of Goods Act, because people bought coal and then they lit the coal in the fireplace and the whole thing detonated, because by an accident, a detonator was actually put in as well by the supplier. It came before a Scottish court in Duke and Jackson. And they said, yes, it is satisfactory quality because the coal itself wasn't actually bad. And in England, a couple of decades later, it says, no, it's not satisfactory quality because you have to look at the consignment as a whole. And if you can't actually use it and it explodes, then it is no satisfactory quality and fitness. The interesting thing is, both cases are on the same law. Sale of Goods Act applies in Scotland and England on exactly the same facts. So the reason is simply a different moral consideration of the judge in the interpretation of the law. Of course, we don't say so, but that's what it is. And we have got an earlier Scottish case, which was supposed to follow the precedent of John Duke in 1921 and didn't like the outcome and was strenuously distinguishing on the facts that this case doesn't apply in his case. I leave you how that is because I don't understand myself the distinction. It is totally artificial, only that it doesn't have to apply the precedent. Another one is a quite interesting example in copyright law. Again, the same facts. and even the same plaintiff. The question was, is there a copyright protection of a performing edition done by a musicologist of late French 17th century court music? Now that music is not protected by copyright, cannot be, but is the performing edition, which the musicologist prepares, protected by copyright? And there's an English case, Sawkins against Hyperion, where it said yes. And in France, in the District Court of Nanterre, Tribunal en Grande Instance, I think, first chamber, yes, same facts, same plaintiff, but different laws in technicality, because the copyright protection philosophy in the UK and France is different. So in the UK, we have got originality means not copied own skill, labor, and capital. So in the UK it would be okay. But in France, it means a sign of an intellectual and personal contribution. So obviously, the legal garb is different, but the moral basis on which these judgments arrived are apparently the same. And then we have got the third one, and that's the precarious principle of nullum crimen sine lege, where it is said, which is an absolute fundamental principle, and fuller, otherwise the legal system falls apart because no retroactivity, especially of criminal laws. Well, not in Scotland. The rule comes actually from Cesare Beccaria, really, de deliti e delle pene. Everybody in Europe knows that if he's a criminal lawyer. In Scotland, they don't know the name, really, and in England, they don't either. And it didn't have much influence in the Scottish Enlightenment in Scotland, which is interesting, because otherwise the Scottish Enlightenment was very European. And what we have still, technically, is the declaratory power of the Scottish High Court of Justiciary to declare something which is meant to be criminal as a crime by virtue of your case in point. And it says that in the case of Bernard Greenhalgh, I agree with his lordship as to the inherent power of this court to repress whatever are, by the laws of God and the laws of morality, mala in se. That means they can declare this a crime. Technically, that's still in existence, that rule. So that means that the substance of the legal rule is not just sort of, somehow colored by morals, but actually the law refers to moral principles itself. The reality nowadays is that there is some sort of, prevaricating of Scottish lawyers who don't actually say that this is still the case, really. And we've got Article 7 of the Human Rights Convention, and actually it doesn't really apply anymore, but it has never been formally abolished. So it is still here, which is also quite interesting. After all, it's a democracy, isn't it? And this is, I would say, a fundamental legal principle. So if law is just, and this is sort of my final point, law is as just, virtuous or evil, as the moralities which imbue it, and that depends on the moral principles of men. And if men are rotten and really evil, the law will be, because its morals are. You can't escape from that. You have got your personal conscience, which is also, as a lawyer, something you can escape from on the basis of certain technicalities of the law. So moral systems and values are not good per se, but have to be critically asked as a lawyer, not only as a moral philosopher. And you can't leave that only to philosophers. It actually is totally, if you could create the moral aspect of the law, if you ignore that, then you actually, it also really with comparative law, with legal anthropology, with history, political science, and philosophy, and law is embedded in all this. So it would be a very restricting approach. And if you have corrupt morals, then you have corrupt laws. So basically, the law is as dark as the morally dark side of the man. And the final thing is sort of David Hume said that already, where he said in 1751, it may safely be assumed that jurisprudence is different from all the sciences, and that in many of its nicer questions, they cannot be properly said to be truth or falsehood in either side. If one pleader brings the case under any formal law or precedent, By a refined analogy or comparison, the opposite pleader is not at a loss to find an opposite analogy or comparison, and the preference given by the judge is often founded more on taste and imagination, his own moral ideas really, than on any solid argument. And public utility is probably the guiding force for, he says, for the courts. Thank you very much.
Thank you very much. Thank you very much. That was a fascinating presentation on a well-known problem in law and morals, law and values. So then the floor will shortly be open. I want to make a sort of introductory, I wouldn't call it a comment, but let's just sort of a contextual background for the first presentation. 2 days ago, it was announced that a South African woman had given birth to 10 children. It was carried on the news, even the radio stations reported it. And I just read something on the BBC also. BBC also reported it. But yesterday, the South African government issued a statement saying that they have not been able to verify this particular information. So then, well, I think I will leave the question later on, but that sort of opens the context of the first presentation as to what do we believe when credible mainstream sources can sometimes get it wrong. Right, the floor is open then. Let's have questions. I don't want to say anything about the second presentation yet. It's an age-old problem. Everyone knows how we've been struggling with drawing the line between morality and law. So who goes first? Question time.
Can I? Sorry.
Yes.
Can you hear me?
Yeah, Pasquale.
Okay. Hi. So at first, I'm really sorry for the late delay. So maybe I lost a little part of Rostam presentation. But I have some questions for Rostam and also for Andreas. At first, for Rostam, how does the perception of facts and fiction change according to ex ante and ex post understanding of that phenomenon or phenomena? And do we connect the points only after experiencing something, or we are able to get something also before? About the second presentation, honestly, I found this one really, really inspiring. And the second presentation, I got lost in translation in many verbs, but so I would like to ask your opinion about some specific points. So what if we apply the naturalistic fallacy to the naturalistic fallacy? It is quite different from the fallacy of from the Isote fallacy. Like in Kelsen words, only because something is does not mean that it is good or ought to be, but as well it doesn't mean that because something is, it couldn't become something ought to be. So that's the point. And can we approach the definition of good in an apophatic way, not apophantic? So can we say what is not good, like in Radbruch's words, something that is really unexcusable in the history of the world. So something that is really bad to be justified or tolerated, and then define what is good, like in negative, in an apophatic way, not in a positive one.
All right. Thank you. We're going to take one more question from Elena, and then we can allow the speakers to respond to the questions. Then we'll move to the next round of questions. So, Elena, over to you.
Okay, thank you, Anthony, and congratulations to both speakers. You were so, your speeches were so detailed, so it's not easy to find something unanswered already. So, just one small question to each one. First, perhaps I got it wrong, Rostam, but you said something, I don't remember which page, that lawyers know that judges and authors proceed to legal fictions. What about the lawyers themselves? Okay, that's my question. And to Andreas, when you were speaking about the Iraqi constitution and this article that is saying Iraqi constitution of 2005, I think, yeah, and that it should not be contrary to Islam's principles and to democracy. Should we judge? Should we have a model for everything? I mean, how should the specific identity and principles of each legal system, of each legal culture should not they be respected? I thought, perhaps I got it wrong, that you were somehow judging it negatively or something like that. Why? Yeah, that's my question. I hope I'm clear. Yeah.
Thank you very much. So let the speakers then respond to the questions in any order they wish.
Yes, you want to go first, or should I? I start quickly. I'm short. Thank you for both questions. First, Elena, in the other way, I just quoted Fuller's statement that he said judges often, but the book that I recently reviewed is by a young Austrian scholar called in German, and she identifies, of course, also like by judges, but there are also legal fictions by legislators, and there are also scholars who may, and everyone who's telling a lie and knows it's a lie is creating a fiction, but not a legal fiction. So generally, yes, I think not just judges, of course.
Thank you. That's my idea too. That's
I can really recommend that book. It's very interesting. But
okay, I think, thank you.
But basically, also like, of course, in law firms, I guess when you set up a company, a notary or something, you're creating a legal fiction. I mean, so I think every field of law has these examples. And to Pasquale, thank you for that. This is not as easy to answer as the previous question in a way, but because it relates to time, I think, and there is, for me, this is very interesting, especially with these contradictions in paradoxes and oxymora. There is a relation to our perception of time, and I have looked into that in my book, and after the book even more. I read, for example, Carlo Rovelli's book, which is very interesting about the order of time. And he says exactly, I mean, he's speaking, I wish I had said that, where he says that even our language is not, our modern languages with past, present, and future is not capable of even coming close to the complexity of the time perception. So that is a huge problem. And I don't want to go down this debate, because this is for physics, I think, to enlighten us. But in the media, it is interesting, of course. Again, it's a paradox, I thought too. What comes first, the chicken or the egg? So is it that someone creates a fiction and then it changes the world and makes it come true? Like there's also an interesting book written in 1898 about a ship called the Titan sinking because of clashing into an iceberg. And only 14 years later, it really happened. And then the name is Titan. I mean, what a coincidence, no? And I have next to me a book actually that says, well, you know, the copycat effect. I mean, we know that unfortunately, very often a news story may trigger imitators. I mean, people copying what they read, like even in crimes. It's sad, of course. You read about a crime or you read about a bank robber, and then you think, that's a good way to get money, and you walk into a bank. The other thing is, of course, that are you capable of predicting things that would happen? And then there is another element that makes it more difficult and more fascinating, which is the kind of self-fulfilling prophecy. And I think this is really something we should look at very carefully in the context of so-called conspiracy theories, because here this term is always used to end all debate, serious debate, inquiring into the causes behind things. I always compare that to antitrust. If I go into a supermarket and you see two milk like for the same price, more or less, from different producers. In American antitrust law, it's called a conspiracy, which only after examining it, you find out it was one or it wasn't. And then you have a competition kind of proceedings by the competition authority. But when it comes to such political and news reports, we never have this investigation that never gives a conclusive answer. But there may well be someone who has the power and the means to influence the minds in a way through fiction and later make it happen. There's a very interesting article, and I finished then here, on Samuel Huntington's book, The Clash of Civilizations, which when I read it, first of all, it's an oxymoron. Einstein said, if you're civilized, you don't clash. Second, it is not a theory. It is a policy. It was a policy in a way. I don't know whether he was used but it became a self-fulfilling prophecy by enacting on a policy to use civilizational differences as an excuse to maybe act in violation of international law. And there's a very good article that says that this is a self-fulfilling prophecy and not a theory. But I stop here to give my colleague also a chance to say, but this is a very interesting question. Thank you very much.
Thank you, Pasquale, for this is-ought issue, whether something which is an ought cannot become an is and the other way around, which is a very apt problem, which is something that in any kind of legal, more sociologically informed aspect is absolutely so. And a sort of more realist approach, also legal realist approach, would see that. Let's take property, because I'm doing property theory a lot. And I did sort of even hint at that when I gave you the presentation. I said, property is, therefore it is good. Well, you can say, what is property? Now, physical things they really are physically there. Property is, of course, a normative construct. So it is an ought. The fact that something is declared property in a legal system and then the attribution to someone makes, of course, effectively the ought to an is, because then somebody has exclusive rights over this resource. And that is not an ought, that is, as factually so. These are things which you can't get away from, and I don't actually have an issue. The Kelsenian approach is sort of keeping the law pure from any kind of factual, also moral aspects, in order to have, as he sees it, a scientific, disinterested analysis of what he sees as law. And of course, certain aspects are quite good. I mean, I think Rostam was as much infiltrated with the pure theory of law when he did constitutional law as I was, because in Vienna at that time, at least, there was no way around it. And it has its merits, but I don't think that this is a complete legal science. And of course, the is-ought problem is a problem, but as you're absolutely right, you ought in order to make something happen, so it is, which then can lead to another ought, because it is, it must be good, but that is not what I necessarily say. So there is property created by the law, therefore it must be good, which is also a chicken and egg situation, actually. What was first? But you're absolutely right that there is a connection and you can't get away from it. I haven't completely philosophically cracked it. If they give me sort of 2 or 3 years research leave in May. But you're absolutely right with that question. The second one is there not a possibility not to say, well, we don't know what is good, but we can probably say what is really not good. And so we have got a negative definition, which Radbruch and so on. Fuller does that as well. You see, I don't have a particular problem with these propositions as such. We mustn't, however, take them for granted. And we mustn't think that this is sort of, the general thinking of the right-minded people, and there are these sort of formula which you find in court decisions quite often, because it isn't. And we have the unfortunate situation that legal principles based on modern democratic liberal values are actually not at all self-evident. The American Declaration of Independence talked about self-evident truths, but I mean, that was in the 18th century where they actually were quite sort of believing in this kind of thing. But in some ways, we have to go back to the 18th century and say, we have to fight for these. They are not self-evident, and particularly they are not shared by everyone, probably not even by the majority of the ordinary people, as we see in all sorts of elections. Because why would you, as a sort of little humble man who actually is out of work, vote for Donald Trump then, who is definitely from the elite, you know, and he's actually trying to wreck the legal system. It didn't quite manage in America because the constitutional system is so strong, and that is also moral, almost religious, that they couldn't wreck it. And everybody went to court in America to actually challenging his decrees in whatever court you could find, which is also quite American. Try that in others, even Western countries, where you don't have that necessarily. But even that is a moral principle. And so you can then certainly have, you know, there should be no retroactivity of criminal laws. In my opinion, there mustn't be a death penalty. We'll have a problem in America about that already. There must be equality before the law. There must be a complete indifference in relation to races, sexes, and whatever, and all these kind of things. And I wouldn't have an issue for that, but you would actually have to stress that these are basic principles on which the law should be founded. And then you need to convince people why, which also means that they have to have a more democratic, normal, ordinary life, for example, in the workplace and various other things, because that is basically what they have. You know, this is their life. 8 hours they sleep if they manage, and the rest is that. And then every 4 years they can vote, and that is meant to be democracy. Why would they appreciate that? You see, so if you are, you know, if you're, for example, if you're black in America, things change completely differently. I mean, it didn't manage, but there are absolutely fascinating things by James Baldwin, also for a lawyer, who you can use in relation to this completely rotten idea of this sort of white democratic system of America. Only as a black person, it just doesn't work out for you. So what's the point of this? And these are things which you ought to mention as a lawyer, specifically when you do law, not only when you do legal anthropology or sociology or history. And this is sort of my point. There is, of course, no conclusive answer to what is then not good or really bad. But one needs to seek to have a consensus by persuasion in a way, and discuss that and not take it for granted, which goes also to Elina's question in relation to the Iraqi constitution and the difference in different legal systems, whether there's actually the necessity, probably the aspiration to take different legal cultures on their own terms without being too judgmental about this. Well, that's the problem. If you have some kind of fundamental rules, or some fundamental rules, you say that is bad, and of course you become judgmental with certain legal principles in different legal systems. It's something you cannot completely avoid. If you can look at the religious system, which is Sharia is, it depends very much on the interpretation, because these moral systems, especially religious moral systems, pretend to be immutable because they are the word from God, so it must be absolutely right and always like that. But in fact, they change enormously. And it is, of course, possible to interpret the Sharia in a way that it is democratic. I mean, this is propaganda that, you know, Islam and Islamic law cannot be democratic at all, and Christianity is. Of course not. They're pretty similar. I mean, there's no much difference at all between these two in relation to their outlook as being dogmatic systems. But of course, it is possible to interpret them, and as a Muslim, you can do that as much as a Christian, to live and to observe a democratic society. It depends, of course, also on the religious leaders. And we have got religious leaders who say, no, this is not democratic. We are not interested in democracy. They probably don't say that so openly, but that's it. But they have certain principles, you know, subordination of women to men and things like that, which of course the Christians have as well. There's no difference whatsoever on that. And so therefore it's not compatible. I mean, I can't, you know, this is an issue then for essentially Muslim scholars, how they do interpret and develop further their moral system. But you cannot say that democracy and, for example, Islam or Christianity are sort of, as it were, together and can actually are compatible automatically. Of course they are not. So you don't actually respect necessarily all sort of moral systems and legal cultures completely. And you can't get away from that unpleasant point. In the Enlightenment, they were absolutely ruthless. They said, no, we are right and we should change and we should kick out and shut down the church. If we look in the Declaration of Independence of the United States, in the original version, Jefferson didn't mention God at all. He was really an Enlightenment man. John Adams did have very little to do with God. They were, you know, especially John Adams, classical Scottish Presbyterianism, really. But he sort of got rid of this idea. We don't want to talk about God and specifically not about the church. And that is the way how modern democracies could come about, because of the emancipation of the church. And the church then sort of caved in and does adapt to it somehow, you know, somehow. And something like that, I hope, will happen with Islam. But we can't avoid the fact that there are, of course, clashes which you can't sort of shy away from by having a purely technical law with norms and systems.
Thank you very much for, oh, sorry. Thank you very much for the detailed answer. But we comparativists aspire to not being judgmental. I don't know if we succeed, but anyway, yeah, your detailed answer was very good. Thank you very much. And thank you both. Thank you both.
Yes, okay. Thank you, Alex, for the questions and answers. Just a matter of housekeeping. We have less than 10 minutes left for our session. So let's take only 2 questions. One starting from Salvatore and then maybe one last one. And then I implore the speakers to keep their responses short so that we can finish before 10 o'clock. Thank you.
Thanks, Anthony. 2 quick questions, one for each speaker. Rostam, I really enjoyed your presentation, and I have a question. I hope that I can make it clear and quick. Starting to you quoted Denzel Washington at the beginning of your presentation about reading newspapers. What about the subtle thin border existing between a situation where the news, you know, you describe the news are facts that are ascertained in principle. So what about the border between the thin border between the situation where the news or the information is true, but the way how it's presented misinform the reader or the person who hear the news, and the situation where the information is false? I mean, you can teach me that the same idea of fake news is an oxymoron, because if the news is something that is ascertained, is true, cannot be fake, obviously. But I see, and also I see a different kind of reaction by the law when the information is true, but it's, I would say, distorted by the way how it's presented, and the situation where the information is false. Also, a big thank to Andreas for his brilliant presentation. For him, I'm interrogating myself on one thing about law and morality and how and the way that law is just. In my view, and I wrote also on this, is we have a trend where the law today is just, I mean, the idea of justice of the law is very personal, in the sense that people perceive the law as just when it meets the expectation of the single person. Actually, when for myself, I would say a different situation or a different way of the application of the law, and actually the law says something different, then the law isn't just. How to reconcile this kind of these things? Thank you.
Okay, briefly, thank you, Salvatore. First, an answer to Andreas. Trump was elected because the Simpsons predicted it, by the way, but that's another case of predictive programming. And Salvatore, yeah, thank you. This is exactly why I concluded in an article that I published on that just a month ago, that we should not try to prohibit fake news, because the line between fake, and not just between fake and true, is very difficult to draw. It is in particular with regard to when is an account true. And I remember, for example, working in a court, and whenever we had a trial, and the next morning I read about the case in which I assisted in the trial, and I knew the file, I knew everything about it. I couldn't recognize the cases, because every journalistic effort is, everyone, by the time you delete a comma, you change the meaning, and therefore it is very hard to fully represent an objective truth and reproduce it in another time and in another context. So I think it is very, very, very difficult to do, and that's why we should not do it. And in particular, I looked also, my title also has mind control. I look now at some practices in AI, for example, about subliminal messages. This is famous in visual, but there are also semantic subliminal messages, where you, by adding words in a certain order, you already influence the mind, and you distort or guide, or you maybe influence, or it is propaganda or censorship, leaving something out. These are all paradoxes which we cannot solve with binary thinking alone, and therefore we need to find better ways of addressing this problem. And one of them, I personally believe, and I've tested it with students in a class last semester on fake news, teaching about paradoxes and contradictions in oxymoron helps a lot in getting a bigger picture about what is truth as we understand it. But more, yeah, thank you very much. And by the way, Anthony, sorry, I also read the story about the lady giving birth to 10 babies. So interesting to know that they couldn't verify it. Thank you.
Thank you. Okay, so let's give the last word to Andres. Do you have anything to say?
Thank you, Salvatore. I think this is sort of just made up when you were asking the question, so I don't really have a sort of considerate answer. But I think the idea is probably that nobody should be judging his own cause in order to define what justice is. So if it's good for me, it is meant to be just, but that's not the point. It has to be sort of from a disinterested source, and then sort of a kind of community which is not directly involved in the interests of this particular case. And out of that, one could probably distill ideas of justice. So if I am not involved, and this is also the reason why we don't actually fight it out with a fist fight, but go to a court with a very formalized system of civil procedure or criminal procedure, in order to safeguard exactly that people are not, because of their own personal involvement, deciding by virtue of sheer power what is just. I think that probably is what I could give as an answer, as a quick one.
All right, thank you very much, colleagues. Thank you to the speakers and all who asked questions. I think all of us will agree this was a very fascinating session. Even though we had only 2 speakers, we more than made use of the views and insights of a very small group. So thank you very much to the speakers, and thank you. Right, so then we shall end this session, and yeah, Salvatore wanted to say something? And yeah, oh, okay, so you are raising your hands now. Yes, Salvatore wants to, yeah, over to you.
We cannot hear you. You have to unmute.
Oh,
No.
okay. Okay, Salvatore was raising his hand, so I thought he had a question. Okay.
No.
So then
I made a mistake with my computer. Sorry for that.
Okay, all right. So we've come to the end of the session then. So once again, thank you everyone, and I hope we see each other again in the other sessions coming forward.
Thank you.
Thank you so much.
Bye.
Bye-bye.
Bye.
Thank you very much.
Thank you.
See you. Bye-bye.